power of attorney is an important part of pretty much everybody's financial planning, or it should be. But it's especially the case for elderly parents and elderly relatives, and yet it's not an easy conversation to have. Yeah, you can imagine it, can't you? Hey, Mum and Dad, sign this piece of paper and hand over all control of your money and your life to me. Of course, it's not like that at all, but the perception may be there in your parents' mind that it is. So we need to dispel some myths, and then if you're having difficulty explaining how it all works, you can just show them this video. So let's put 5 minutes on the clock to the left here in the fancy new thermometer style. Say a quick thank you to my friends at 7 Investment Management for continuing to sponsor the show. And let's crack on. Okay, for the rest of this video, I'm going to be talking as if I'm speaking to the person thinking about taking out the power of attorney. Okay, it's just easier that way. Now, the first thing to know is that these days they are called lasting powers of attorney, or LPAs. They used to be called enduring powers of attorney, and then there was actually something called an ordinary power of attorney, usually just called power of attorney. So these things might sound the same, but they're not. So lasting power of attorney is what we're talking about now. Now, arranging a power of attorney gives your attorneys, that is the people you have nominated to act on your behalf, the power to make decisions for you. The idea is that you arrange this before it's too late and you've lost the ability to make your own decisions. That's called losing mental capacity. Now, there are two types of LPA, and the first is property and financial. This gives your attorneys your authority to make decisions for you in relation to your property and your finances. So your attorneys can then deal with banks and building society accounts, investments, insurance companies, utility companies, the council, anything really related to your money, your possessions, and your home fall under this power. And then secondly, you have the health and welfare LPA. And again, this is intelligently named. We're talking about medical decisions and potentially long-term care, what home you might end up in, what in-home care you might need, decisions on medical intervention of any kind, and even end-of-life care. All of that falls into the remit of a health and welfare LPA. Now, it's worth knowing that if you have an old-style enduring or ordinary power of attorney, those can't be used to make health and welfare decisions for you. You're going to need a new style health and welfare LPA, lasting power of attorney, for that. So let's talk a little bit about admin. With lasting powers of attorney, you've got to fill in the forms, and they're not too challenging, but they're not easy either. Fill in the forms and send them off, and there is a fee of £82 per power. So, if you're in a couple and you take out both kinds of lasting power of attorney each, that's a reasonable fee. 164 times 2, 328. Good mental arithmetic. So you fill in the forms, you send 82 quid per form to the Office of the Public Guardian. And that then logs the power of attorney with the OPG, but crucially, it isn't triggered at that point. Hear me on this, it's really important. The lasting power of attorney isn't triggered when you register it with the Office of the Public Guardian. Health and welfare LPAs are only triggered if you lose mental capacity. That is, you're no longer deemed able by medical professionals to make decisions for yourself. So it's not if your kids think that you've lost mental capacity, it's if a medical professional does so. Now, that also applies to property and financial LPAs, but in that case, you can actually trigger them voluntarily as well. And that isn't really about handing over control altogether, unless you want to. In this case, and how it very often happens, is that you work with your attorney to manage your financial affairs. So maybe you've got mental capacity, no problem, but you're not physically able to go out to a bank or a post office or whatever. Then your power of attorney can do those tasks for you. Let's talk about restrictions. It's really important to understand that an attorney can help in many ways, but they're also really restricted in what they can and can't do for you. They can't give money away other than what you could reasonably be expected to give, say, for Christmas or birthdays before you lost capacity. And they can't do anything which directly benefits themselves. They're supposed to act entirely independently. And there are potentially criminal penalties for people found guilty of abusing a power or for willfully neglecting their donor. That's you, the person giving the power. And if you suffer loss as a result of your attorney not doing their job properly, they could be forced to compensate you. And for that reason, and for many others, you really do need to choose your attorneys very carefully. Notice I said attorneys there. You should ideally have more than one and have them act jointly and severally. That means that they can make a decision and act even if only one of them makes that decision. Now that might sound dangerous, but if you set up a purely joint power where your attorneys have to make every decision together and one of those attorneys dies, the power is now useless because you've forced all decisions to be made by two people. One of them's not there. They can't be made by two people anymore. So really important thing to remember. Obviously, you should choose people that you can trust. Could be a family member, close friend, or a professional like a solicitor. So what happens if you don't take out a lasting power of attorney? Well, if you lose mental capacity without an LPA in place, somebody's going to need to apply to the Court of Protection to become your deputy. Now that's similar to becoming your attorney, but the process is much lengthier, much more costly, and in the meantime, no one is making decisions for you. Now the court could appoint someone that you don't know to act for you, which to my mind is just unthinkable. Far, far better to address all this in advance by setting up LPAs ahead of time. Remember, they only kick in when they're needed. They sit there waiting to be triggered if necessary, but once they're in place, they offer serious peace of mind. You can do the forms yourself, or you can pay a solicitor or a will writer or similar to do it for you. If in any doubt at all, seek legal advice. You really need to understand the implications for you and your particular circumstances. Legal advice will always be worth the money that you spend on it. Okay, hopefully that was a helpful summary of lasting powers of attorney. Really important piece of paper that everybody should have, not just if you're in the later years of your life. Really, anybody should have one. Next week, we're going to talk about how to make the process of handing over control to your attorneys or to your family or whatever as easy as it can be. Thank you so much for watching. I'll see you in next week's 5 Minute Friday.